Hi, all. Thank you for coming. I'm going to get us started quickly because we have so much to cover in an hour, as Professor Farber was just saying. I'm Catherine Lehman. I'm the Executive Director of the Edley Center on Law and Democracy. I'm so excited that you all came out to join us for today's really crucial conversation. I think it's among the most important topics at stake in our democracy today, and I feel very lucky that we have these two tremendous experts here with us for an intimate Friday afternoon conversation about presidential power under President Trump. And with that, I will just say that we have two of the nation's foremost administrative law and executive power experts with us in conversation. They're going to jump in. They're going to be talking together. If they are able to close in time for some questions, I'll have the microphone and I'll walk it around, but they don't guarantee that they will, so we'll just all listen for now. Thank you.
Well, thank you so much. It's so nice to be here with Professor Farber and with all of you today. And the reason that we hedged a little bit about Q&A is just because there's simply so much to discuss when we are talking about executive power. So we are going to try to get through as much as we can. You may well have questions about things that we don't have time to cover, so we'll try to leave you some time. And Dan, I don't know about you, but I think a good moniker for what this administration has done, the second Trump administration, in terms of presidential power can be encapsulated by the phrase move fast and break things, which we usually use to refer to the private sector. It's more of a corporate mentality for startups. You know, we're close to Silicon Valley here. But that seems to be very much what we've seen in Washington, at least to my mind. And the image that I know is, we've talked about this a little bit beforehand, is stuck in both of our brains that kind of represents this approach is the demolition of the East Wing of the White House, which took place recently to make room for a new ballroom that the president has planned. And I think, you know, the speed at which that demolition occurred and the response of a lot of the members of the public, whether they were in favor of the new ballroom or against it, was sort of like, can he do that? So that's one of the questions we're going to try to answer today.
Great. I know there are 1Ls present because a bunch of my tort students came here today, which is great, but I want to assure you this won't be on the final. They all get up and leave. But since a lot of you may not have taken con law, I wanted to start by just giving a bare introduction to sort of the two contesting ways of thinking about this field. And I'm going to start with one that I think is now most conventional among judges and scholars, but not uncontested. And the conventional approach goes back to an opinion called the Steel Seizure case during the Truman administration. And I'll spare you, in the interest of time, the background on the case. But the important opinion in the case actually turned out not to be the majority opinion, but a concurring opinion by Justice Robert Jackson, in which he divided the universe of presidential actions into three buckets. In the first bucket, you have actions where the president is acting pursuant to congressional authority. And in those, the president's power is at a peak because he's representing really both branches of government. All the power of the federal government. And the only real question is whether the federal government has that power. In the second bucket, we have situations where Congress hasn't authorized something, but it has not forbidden it either. We're in kind of a gray area. There might be some signals about what Congress likes or doesn't like, but no clear legal directive. And basically, in those cases, Jackson said those are really hard. And courts have kind of struggled with it. They often look at things like, is there a past history of presidents doing similar things that Congress seemed to accept, and so forth. And then there's the final bucket, which are things that the president has done even though Congress said no. And there the president's power is at the narrowest because he can only rely on powers that the Constitution gives to him specifically where he can argue that the grant of power to be, I don't know, commander-in-chief or something trumps whatever, I usually try to avoid that verb, whatever power that Congress might otherwise have, right? So that's sort of the conventional approach, and it's one that gives the president the power to do some things without specific legal authorization, but tends to look skeptically on things that are prohibited by Congress unless there's a really strong case on behalf of the president. Now, the contesting view is one that I think, in a sense, puts everything in the third bucket, one way or another. That is, it sees the president as having very broad, preclusive powers that Congress can't touch. People often call this the unitary executive. That's a bit of a misnomer. The unitary executive theory, strictly speaking, is just about the president's control within the executive branch of the government. But people who are strong believers in that are often also strong believers in inherent presidential powers in other directions. And in both cases, they find the authority largely in the sort of opening language of Article 2 of the Constitution, which vests the executive power in the president. So one of the differences between this and the more conventional view is that this view sees that grant of executive power as being very broad and not simply the power to like execute the laws or something, but a power to undertake a broad range of things, especially relating to national security and foreign affairs, but also to some extent to emergencies and other areas. So that's kind of the basic back and forth. Some of the Supreme Court's recent decisions have sort of had language that veered more toward the second view, especially in the Trump immunity decision, I think. But we're still in the process of finding out where the court actually is going on this. So the way we wanted to organize this is talk about some key areas very quickly where President Trump has been, exercising his muscle. And then we'll talk about some of the checks on presidential power. And if we have time, we'll talk about some general themes. And I really hope that we will have time for Q&A. That's always the best part. But it is a tribute to Trump that there is so much for us to talk about that I just don't know if we'll get there.
So I am going to take the first key area, and I thought I'm going to try to be brief, but it's really hard, as Dan said, and because the area I'm going to be talking about is under the broad heading of redesigning the government. And this follows nicely from what you were talking about in terms of the unitary executive, different theories of executive power. This is one area where we see the tensions between those two theories playing out. How much control does the president have inherently to remake government, specifically to remake the executive branch of government and or what we might think of as all of the agencies of government? So, historically, the conventional view has been that Congress is the architect of the administrative state. Right? Congress is the architect of administrative agencies. They pass statutes that create agencies, structure them, specify what their offices and duties shall be, and other details. And then the president is tasked under Article 2 with taking care that the laws are faithfully executed by those actors. There have been times in history where Congress has delegated more authority to the president to structure the executive branch. So Congress has delegated reorganization authority multiple times to the president. And using that authority, presidents have done things like create whole agencies, like the Environmental Protection Agency, for instance, which was created by, perhaps surprisingly, Richard Nixon, and have reorganized agencies under that authority. But that was statutory authority, and all of that reorganization authority has now lapsed. After the demise of something called the legislative veto, and the Supreme Court held in INS versus Chadha that it was unconstitutional for Congress, either as a whole or for one house, to veto actions taken within the executive branch without going through the legislative process, Congress didn't have as much appetite for delegating that authority to the president. So in other words, they only were comfortable with the president reorganizing government when they had a veto, when they had a say. So the president no longer has that statutory authority, but presidents, of course, are interested in remaking government to suit their own policy priorities and purposes. This is not something that is unique to President Trump. But I do think that in this administration, we've seen President Trump take a more aggressive approach to remaking agencies. And there's sort of several aspects of this that I want to talk about, but I want to preface it by saying that in an article a few years ago, my co-author Jody Freeman and I approached this whole subject by talking about what we labeled structural deregulation. So this is a version of deregulation that is not substantive, it's not the repeal of laws or regulations, it's achieving deregulation, less federal government regulation, by actually restricting the capacities of the agencies that do that regulation. So that's kind of how we like to see what's happening here. And there are several aspects of it. One has to do with personnel and staffing. So, there are people that work at the top of these government agencies, and many of them can be removed by the president for any reason. Cabinet secretaries, for example, the president can remove the Secretary of Energy if he's not happy with how the secretary is doing his job. But we also have agencies we've come to think of as independent agencies, where Congress in their statutes creates removal protections for their heads. These tend to be bipartisan, multi-member commissions. And for whatever reason, Congress has deemed that their activities should be more insulated from politics. And so they'll put into place removal restrictions that still allow the president to remove the heads in cases of sort of bad behavior. Right? We call this for-cause restrictions, neglect, malfeasance in office. But otherwise, the president has to let them serve out their terms. Now, this has become something of a contested concept. Maybe it's always been a little bit contested. And the Supreme Court has been ambivalent about this over the last 100+ years since we started seeing the rise of these independent commissions. But there is a decision from the 1930s called Humphrey's Executor, in which the Supreme Court clearly holds that Congress may put these removal protections in place. Recent Supreme Court decisions have suggested that perhaps a majority of the Supreme Court is willing to rethink that opinion, or at least to confine Humphreys to its facts pretty narrowly, giving the president more authority to remove independent commissioners. However, there is no Supreme Court decision yet that has done that. President Trump, notwithstanding that fact, is testing the waters here by removing a number of heads of independent agencies, including at the National Labor Relations Board, the Merit Systems Protection Board, the Federal Trade Commission, the Consumer Product Safety Commission, the Nuclear Right, you get the idea, right? There have been a number of these removals, generally of Democratic members of the commission, in other words, the commissioners that were appointed because they were of the Democratic Party rather than the Republican Party. And in some cases, that has left commissions without a quorum, meaning that they cannot take many of the actions that Congress has assigned to them. They have too few members under the statute to do that work. And so that is one way in which agencies have been limited in the kinds of work that they can do. Another aspect of this has to do with just line-level civil servants. So people who are hired with the civil service protections that we think of as protecting employees of the federal government from termination for, say, political reasons and other reasons. And what we've really seen is this is an administration that thought the government was too big, that made no secret of its desire to shrink the size of government, and has gone about that diminishment in several ways, each of which has been tested in court or is in the process of being tested in court. So the termination of probationary employees who did not yet have their civil service job protections. Tens of thousands of employees were terminated on that basis. There was an email that went out that you may remember called the Fork in the Road email early in President Trump's term that was essentially a voluntary retirement offer. And it said, if you can stay on for X number of months, you won't be working anymore, but you can collect your salary for these number of months, and then you leave if you accept our offer, kind of surrounded by this not so subtle implication that big layoffs are coming, so maybe you should accept this offer. That yielded about 150,000 retirements, the latest estimate shows from the federal government. And then there are these more formal measures called reductions in force, which is a statutory process that's laid out by which agencies go through established steps to determine, sort of which employees, based on their, nature of their job performance, their how long they've been serving, their performance should be removed because the agency needs to shrink its size. So we've seen that in play as well. And then, of course, in the recent government shutdown, which shows no signs of abating, the administration has at least gestured at making additional large reductions in force during the shutdown. So lots of actions with respect to personnel. We'll talk about some of the lawsuits a bit later when we talk about courts. Several of these lawsuits have been at least successful at the district court level in challenging these moves for failure to follow established statutory procedures, for example. But one of the really interesting things about the personnel moves, to my mind, is that the bureaucracy of the civil service relies on certain offices and certain officers to ensure that the civil service protections are effectuated. So we have the Office of Special Counsel, who brings lawsuits or internal claims on behalf of administration employees who have been terminated and think that there have been violations of policy in those terminations, whistleblowers who think they've been retaliated against, and those claims are heard in front of the Merit Systems Protection Board. And one of the first things that President Trump did was remove the special counsel in the Office of Special Counsel, and has also removed members of the Merit Systems Protection Board, leaving them for months and months and months without a quorum. So that internal functioning is also not working quite as intended. Just briefly, there are a few other ways that the administration has tried to achieve a shrinking of government. One is, of course, by having agencies hold back funds, either for grants or for aid programs or for other aspects of their work. This is actually generally not legal under a statute called the Impoundments Act. Yeah, but they have done so in many cases. Those have been challenged in court as well. So an agency without full personnel that can't spend its money isn't doing as much. In some cases, agencies they're still there on paper, but they're not necessarily there in practice. So you think about USAID, which Elon Musk, who was the head of DOGE, which was in charge of coming in and advising on cuts at the beginning of the Trump administration, said he spent the weekend feeding it into the wood chipper. And I don't know, how inaccurate that is, because there are no employees, I believe, working there anymore. Funding's not going out. There are a couple other agencies like that have been really hollowed out. The Department of Education's Office of Civil Rights, with apologies to our executive director, the Consumer Financial Protection Bureau, the Voice of America, which is responsible for radio broadcasts. And so it's an interesting situation in which there are agencies that exist on paper in statutes and maybe don't really exist in the federal government anymore. So that is a pretty dramatic approach, I think, when you look at it in history, to reshaping the federal government.
So I'm going to switch gears a little bit and talk about another type of action that President Trump has taken that other presidents certainly have used themselves, but I think not on the same scale or as aggressively. And that's the use of what you might call exceptional powers. That is, national security powers and emergency powers that the president may have. The president may have some inherent national security powers internally, clearly does externally outside the country. But many of the president's powers for national security and for dealing with emergencies are actually statutory. For example, there's something called the National Emergencies Act, where Congress authorized the president to declare a national emergency. And there have been quite a number of them the presidents have declared over the years. But that declaration by itself doesn't do anything. What it does do is trigger, I think, well over 100 other statutes that contain language something like, in the event of a national emergency, the president or maybe an agency can do X, Y, and Z. An example of that involves a tariffs case that was argued earlier this week, which we're going to come back to. But the president there claims to be operating under a statute called IEEPA. And I'm never sure if I'm getting the actual words in order, so I'm going to skip that. But this law authorizes the president to do quite a list of things to foreign movement of international transactions of various kinds, sale of goods, capital flows, et cetera, and to property that's owned by foreign nationals. And the big question in the case is whether that list implicitly includes tariffs, even though it doesn't explicitly refer to them, right? But that case is typical in that perhaps the president would claim the power to institute tariffs all on his own, but he doesn't have to because there's a statute that at least allows him to do a whole bunch of related things to international trade, like cut it off entirely. But that's only one of many laws, right? And the president has been very aggressive about using those laws and using other sort of claims of emergency authority. So just to give some examples, there's domestic use of the military, right? So there are, National Guard in several American cities now. DC is kind of a special case because it's federal, but in these other cities, the claim is that there are, essentially unsettled conditions that threaten the enforcement of federal law, and that there's a statute that then allows the president to send in the National Guard if those circumstances are satisfied. Another example of, I think, unprecedented use of such powers involves the Alien Enemies Act of 1789, right? You haven't heard of that before because it's only been used like 3 times or 4 times since 1789, and all of them were in declared wars, right? But President Trump has argued that this law applies to members of Venezuelan gangs who he views as being at war with the United States, and that he has tried to deport basically without any kind of hearing. The Supreme Court did push back on that and gave them some right to be heard about deportation. And the lower courts have been struggling with the question of whether the statute even applies at all in the circumstances that we have before us. I'm pretty confident that that issue will get up to the Supreme Court unless all of the lower courts agree. But I think otherwise, I think it's sort of a sure thing. Declaring an energy emergency. Now, the lights are on. The HVAC system is working because I can hear it. The mic's working, right? So why do we have an energy emergency? Well, the reasoning is that we're going to have a big surge in demand on the power grid, or at least that's the primary argument, on the power grid, largely due to AI, and that there's a risk that the grid could break down. In addition, according to the president, AI is crucial to our competition with China, which is also trying to develop newer and better AI, and that's a national security interest. Now, He can't arrest people under that energy emergency, or at least they haven't, I don't think they figured out a way to make that work. But that has been used at least as a justification for shortcutting all kinds of permitting processes that would otherwise require a lot more in the way of safeguards for imposing orders to keep coal-fired generators open and operating. Professor Jacobs is the world's leading expert on that particular issue, and so on, right? So again, emergency powers. And executive powers do tend to grow during emergencies, so this is not totally unexpected. But I think the scope of what the president has tried to do, and then even though our focus is really domestic rather than international, as such, there's also bombing Venezuelan boats that are non-military and may not be headed for the U.S. in any event, but who are suspected of carrying drugs, right? And again, this is a pretty unprecedented use of executive authority that goes beyond previous cases. Like, we've used drones quite a bit in parts of the world, but that actually was under congressional authorization and something called the Authorization of Use for Military Force that doesn't apply here, right? So this is also relatively new territory for the president.
And hopefully we'll be able to get into this a little bit more later, but if you think about the presidents in our history who have dramatically expanded powers or sought to expand the powers of the presidency, a lot of those expansions have taken place during times of sort of genuine national crisis, right? You think about FDR and the Depression in World War II. You think about George W. Bush and the aftermath of 9/11, right? And some of the military and also sort of domestic surveillance powers that were assumed at that point. It's really, I think, it is advantageous to a president that wants to expand powers to be responding to some kind of emergency. Not that these presidents asked for those emergencies in any way, but those tend to be moments at which it is possible for the president to expand powers. And so you can see why declarations of national emergency of one kind or another would be a very appealing tool for presidencies. President Biden, for example, was being pushed and really seriously considered declaring a national climate emergency. Right, and sort of there was internal debate about that within the executive branch because that would unlock the ability to take actions that weren't otherwise available. So you declaring a national energy emergency, for example, unlocks a whole series of powers, whether we or not we agree. And this might be a useful time to just circle back to that question of can he do that? Right, which is can you write an executive order and declare an emergency where there might be reasonable room for debate about whether an emergency genuinely exists. I mean, my personal view is that we are not in the middle of a national energy emergency, and there are several sort of factual claims in the executive order that I think are incorrect. So what does the law have to say about that? Well, we don't have really good settled law on exactly how we challenge executive orders directly, right? They're exempt from a statute called the Administrative Procedure Act that's used to challenge agency action. The president can't act unconstitutionally, and we have the Youngstown framework, but in the lawsuits that are trying to get at the crux of this executive order on energy emergencies, sometimes the best way to proceed is to wait until the executive order produces action within the administration, and then you have more statutory tools to challenge what agencies are doing pursuant to it. So aspects of the order may be tested in that context, and there are already several lawsuits that are working their way up.
Then the final area that we wanted to talk about in the sort of survey of Trump's actions.
Oh, I think I have one more before that.
Oh.
Sorry.
Yes, you're right. Sorry.
There are too many things to talk about. I was just going to say a few words about the targeting of enemies, because this is something, when President Trump came into office, and during the campaign, he said repeatedly that what he was going to try to do was going to reverse the weaponization of government, the weaponization of the Department of Justice. He felt that government had been used unfairly to target him and some of his allies. And so he wanted to change that. And I think what we've seen is actually arguably a weaponization just in a different direction. And so I just want to tick off some instances of what we might call targeting of enemies and opponents by the government. And so, we've seen some targeting of personal enemies of the president's. For example, individuals involved in lawsuits against him or who he deems to have wronged him in the past. Special Counsel Jack Smith, for example, who is now the subject of a suit. Letitia James, the Attorney General of New York, right, who is being scrutinized for behavior in mortgage applications. James Comey, right, the former FBI director, for his sort of activity leading up to the 2016 election. Andrew Weissman, who's next, right? Senator Adam Schiff. There have been discussions about that. So there's a long list of folks that the president has not been, he's not been covert about this. He's been very upfront about the fact that he thinks that these are people who have done something wrong and should be investigated. The suspension of security clearances is another area where we've seen kind of a specific kind of targeting of folks that the president is not terribly fond of, like former President Biden, former Vice President Harris, for example, Alvin Bragg, the Manhattan DA, who was behind one of the lawsuits against President Trump. Law firms that are associated with some of these individuals, so this is something that here at a law school ourselves, there's been a lot of attention. These were efforts to suspend security clearances for some of the people who worked at law firms, but also directions that the federal government terminate work with particular law firms and other actions. And many of the law firms that were targeted in this way made deals. I think Paul Weiss may have been the first law firm to make deals, but they certainly weren't the only ones. Some of the law firms didn't, right? So my alma mater, Covington and Burling, took a different approach, challenged these actions in court and won. But certainly that was something that was happening early on in the administration that I know is top of mind for a lot of students. The press, right? So cuts for public broadcasting have been a feature of this administration. I think PBS just announced it was cutting something like 15% of its jobs because Congress, in response to a request from the president, clawed back $1 billion in funding for public broadcasting. There have also been lawsuits filed against individual outlets in the press. So the New York Times, right, is fighting a $15 billion lawsuit for defamation against the president. There have been multi-million-dollar settlements with other news outlets like Paramount and ABC. There has been a reshuffling in how press can access buildings like the White House and the Department of Defense. So there's kind of a rethinking of which outlets should be involved in that process. Universities, right? So we sit here today at one of the universities that has been a target of investigations by this administration, but we are not alone. Right? Columbia, Brown, Harvard, and a variety of other institutions have seen either their research funding pulled back or investigations launched into their practices. And of course, as you're all aware right now, a letter was made public showing that the Trump administration has asked for $1 billion from our sister school, UCLA, and listed a variety of demands as part of the settlement that they hope to achieve. So, that's another version of targeting. Nonprofits and foundations. The administration has recently started talking about the Ford Foundation and an interest in revoking their nonprofit status. There was a government investigation of Act Blue, which is a big platform that helps Democrats raise money for elections. Foreign students, right? Some of you may have been directly affected by some of this administration's actions when it comes to visas and travel. The administration recently said it has revoked 80,000 visas. And that's sort of the first information we have about numbers there. And then the military, right? There was just recently an interesting article about the removal of heads of different parts of the military and kind of speculation about why this might be. But I think it's pretty clear that Secretary Hegseth is intent on reshaping the military, right? And translating it into a force that aligns better or more closely with his vision and the president's vision.
Okay, we have one more area to talk about. repeating myself a little bit. And that's sort of the flip side of the targeting enemies, which is what you do for your friends and what your friends do for you. And one thing that we've seen in this administration are conflicts of interest on sort of a heroic scale. Deals involving crypto, which have resulted in the Trump family becoming $2 billion richer since last January. And that's only one thing. And then sort of less direct things like firms donating millions of dollars for the new ballroom that Trump wants to build, or for other, sort of Trump-favored projects. We've had really the federal government get pretty much entirely out of the business of investigating political corruption. That part of the Justice Department has, more or less been shut down. An early executive order put a pause on enforcing the Federal Corrupt Practices Act. I'm not sure. I don't know that the pause itself is still formally effective, but I believe that as a practical matter, we continue not to have enforcement in that area. The Hatch Act, which prohibits partisan acts by the federal government or federal employees. We have, for example, airplane or airport, statements from the federal government saying, if there's a problem with your flight, it's the fault of the Democrats. They're the ones, they've caused the shutdown and they're messing up the air traffic system. So we've had a whole lot of things, really almost any one of which would have been a major scandal under Biden or Bush, or probably even under Trump 1, many of them, but which now we barely notice, right? But this has, I think, apart from sort of undermining the sort of neutrality and impartiality we expect from government, also creates a kind of crony capitalism in which investing in innovation is good, but investing in political influence is even better for your business. So I think, although it's not, in some ways, it doesn't have the drama of their repressive actions, but this kind of sort of soft corruption may be, in fact, even more damaging to democracy.
Sorry, I'm doing a mic switch here. It's like changing outfits. So, those are just some of the actions that we've been following. And we wanted to talk a little bit about checks and balances, because this is one of the foundational principles of our government, is that it was created for ambition to counteract ambition, so that no one part of our federal government would be able to assume too much power. So this is always a question that comes up when we're talking about presidential power or judicial power or the legislative power. And the first possible check on a president is, of course, Congress. And I think that one of the defining features of the era in which we find ourselves, and this is not unique to the Trump administration, I think we've been seeing this for quite some time, is that Congress has really started to relinquish its role as a check unless you have true divided government. So in situations where it's unified government and the same party controls the presidency and both houses of Congress, and in situations where you have a divided government in the sense that one house of Congress is in the hands of Republicans and one is in the hands of the Democrats, it's been very hard for Congress to assert its own prerogatives in a way that limits the executive, and maybe hard is the wrong word. There doesn't seem to have been the will by members of Congress to assert those authorities. And one of Congress's core powers is, of course, legislation, right? And so Congress should have an interest in seeing that its legislation is followed. But Congress has seemed remarkably uninterested in ensuring that that is the case as, for example, agencies that it created are disrupted in various ways. Congress has a lot of other tools, notably the power of the purse, right? Congress is supposed to be in charge of federal spending, and the Impoundments Control Act, which was passed after President Richard Nixon, really pushed the boundaries of trying to withhold spending, and I think withheld up to 20% of non-entitlement funds during his presidency. Congress responded to that with a statute and said, this is not your job, this is our job, this has gone too far, and we are going to restrict the ability of future presidents to do this. Members of the current Trump administration have expressed speculation about whether that statute is constitutional, and have seemed to just, in some cases, behave as though it were not there, and have also sort of pushed little loopholes that may or may not exist in the law, such as sort of these pocket rescissions at the end of a fiscal year, where there is a process where the president can ask Congress not to have certain funds spent during the year. It's asking for a rescission, and there's a 45-day period. The president has to notify Congress. Congress has 45 days to decide what to do. If you do that closer than 45 days before the end of a fiscal year, it effectively nullifies the spending for that fiscal year. And so the president has used that technique to sort of hold back some funds. So you'd think that Congress, right, would be a little bit more interested in ensuring that its legislative power, its power of the purse, are still vital instruments in our democracy. And one of the reasons that Congress may no longer be so interested in this approach is because one thing the founders, I think, didn't really look ahead to was the strength of political parties and the rise of these two extremely strong political parties, which means that we can't really understand the separation of powers between the branches without understanding sort of where the partisan alliances are. And so, for many members of Congress, it has become, taboo to break with the president of your party on any issue. And I think that we've seen that in this presidency, we've seen that in Democratic presidencies as well, which means that Congress's ability to act as a check on presidential power is considerably muted.
Yeah, I do think that's actually become a stronger factor due to polarization. Mm-hmm. There was a time when there were Democrats who were to the right of some Republicans in Congress, and that allowed more opportunity for dissent within the party. But these days, that's much less true. And then I also think it's fair to say that Trump has asserted a much more powerful grip on the party apparatus than previous presidents, through showing that he can successfully make sure that people are primaried and lose their seats. So this is a long-term trend, but one that we're especially seeing right now. Another check on the president historically has been within the executive branch. And for quite a long time, it was a very powerful check in which presidents wondered if anyone out there was listening to them to some extent, right? Where they would want to change in government policy and it might just not happen. And presidents, since Kennedy maybe, since Nixon for sure, or Reagan, have really taken a lot of steps to increase their power within the executive branch. Some of it under the guise of the unitary executive theory, but others, through less dramatic assertions of authority. So that now, if the federal government does anything of really prominent policy significance, you could be sure that the White House was involved. And despite that, the rest of the executive branch has operated to some degree as a restraint. And we saw that at several levels. You would have cabinet members who would push back on presidential directives. There were a couple points in which, say, attorney generals under, say, Bush, for example, refused to sign off on things that the president wanted. Even in the first Trump administration, we saw cabinet members, including at the attorney general level, pushing back on some things. We also saw that from the Secretary of Defense. and from others. And then the civil service can push back by, saying that some things are illegal, by leaking them to the press, and doing sort of other forms of foot dragging. And one of the things that we've seen, partly because of the sort of triumph of the unitary executive idea, but also, for just other pragmatic reasons, is that that's been much less effective in this administration. I think the Trump people sort of learned their lesson in the first administration, and they read Project 2025, and they realized that if they had a strong enough political position, they really could knock a lot of that stuff out of contention, right? So they have largely been able to appoint as cabinet members people whose sole and undivided loyalty is to the president, and down, to the sub-cabinet level. As we heard earlier, they've sort of, besides sort of, waging warfare within the civil service, they've also taken a lot of steps to silence dissenting voices. A whole bunch of people in the Justice Department have gotten fired for filing a brief that they didn't like, or saying something in court, or even being suspected of having views that were inconsistent with the administration. And so that's been a much weaker force in this administration than it has been in the past. One of the interesting things going forward, I think, will be the extent to which future presidents sort of continue this sort of pattern of iron control within the government, or whether there might be a move in the opposite direction. And sort of, for example, it was considered really taboo to order prosecutors to bring a specific case, or even to, in some cases, really closely monitoring what they were doing, because that could be interpreted as control. And we've seen the complete collapse of that, where the president is, basically assigning prosecutors to go after specific individuals. Will we try to rebuild that norm of sort of Justice Department independence and professionalism, or is this going to be a permanent change? We don't know yet.
One area where I also think we've seen a permanent shift, not just in this administration, but over the past several administrations, has been in terms of the states acting as a check on the federal government, and the states acting as a check on the president. And I see a few of my energy law students here in class this week. We were doing kind of a set of two problems, one in which President Biden suspended all exports of liquefied natural gas, all permitting for that, and was immediately challenged by a coalition of red state attorney generals. And then another in which President Trump, at the beginning of this term, suspended all permitting or all leasing of lands for wind development on the Outer Continental Shelf, and was immediately sued by a coalition of blue state attorney generals, right? So I say this because this has become a real pattern, where we have coalitions of states that are led by co-partisans bringing lawsuits against actions of the federal government, and that has been a key source, I think, of presidential accountability, as these lawsuits can result, notwithstanding the decision, the Supreme Court's emergency docket decision in Trump versus Casa, right? It's still possible to get broad relief when you have a coalition of attorney generals bringing lawsuits on behalf of their states, where courts can sort of freeze presidential action, at least while the cases are decided. On the other hand, I think that this presidential administration, perhaps in particular, has been especially assiduous in its efforts to rein in state power. And that has occurred both in the domain of elections and electoral power, where the administration would like to see certain changes to the electoral process, which of course historically has been largely controlled at the state level. The presence of federal election monitors in certain types of races. There have always been federal election monitors, right? I don't want to overstate this, but the decision about where to send those election monitors is something that's worth watching. And on climate and energy, which is, that's an area that we both spend a lot of time in, an executive order that actually says, I would like the states to be investigated for their kind of renewable energy climate activities, and to the extent possible, find laws to prosecute them for some of these activities and some of these goals. So I think there's a clear desire by the federal government to get more involved in certain aspects of what states are doing. At the same time, the states still remain a really vibrant check on federal power in general and presidential power in particular.
And turning to another area, which I think you kind of provided the transition to, what role are the courts taking? I guess I should begin by saying nobody can accuse the courts of being missing in action. There have been, this number is old, so I'm sure the true number is higher now, but there have been at least 300 lawsuits filed in federal court against the Trump administration. I wouldn't be surprised if we were up to 350 or 400 or something like that. Many, many, many cases. And the plaintiffs have had quite a bit of success, especially in the district courts, where something between a quarter and a third of those cases have resulted in either interim or permanent relief from the district court level, like a temporary restraining order, a preliminary injunction, or a final injunction, or other type of remedy. And courts, lower courts have been especially active in certain areas. We talked about the law firm issues before. There have been, 3 or 4 cases filed by law firms against the Trump administration, and the district courts have sort of vied with each other to express how outraged they are by the executive orders targeting the law firms. There are other areas, some of the immigration stuff, National Guard things, grant cancellations, some of the civil service stuff, where the lower courts have been very assertive. And I think that the administration would have gone a lot, even broken more things and gone faster if it had not been for that. Now, the Supreme Court has, sort of been a different picture in that the government has taken 30 cases maybe by now, in the high 20s, where there was a relief granted by a lower court and asked the Supreme Court to stay the lower court order allowing the government to go forward. And the government has won at least partial stays in all but a handful of those cases. Not all of those are complete wins. For example, they got some relief from the Supreme Court in terms of the Alien Enemies Act that I mentioned earlier, but the Supreme Court also made it very clear that the people in question were entitled to due process and the right to contest their deportation, which the government was not happy about at all. So it's not quite as one-sided, and it's also a little hard to interpret because that's like 10% of the lower court cases altogether have gone to the Supreme Court, or maybe 20 or 25% of the ones where there were injunctions in the lower courts. And the government's been smart about picking its cases, right? So it has tended to go for cases where it was on strong ground. It is often appealed on the basis of standing or on the basis of issues relating to the remedy that could be imposed. So that it hasn't necessarily, the number of cases where the court has given a strong signal of support for the government on the merits is much smaller. And that brings us to I'm trying to avoid elephant in the room, but I can't come up with something better, which is the tariff case that was argued in the Supreme Court earlier this week. And I think that may be about all we will have time to talk about beyond what we've already said, but it's well worth spending the time on. So I thought I'm going to just sort of go a little deeper into the facts of the cases to give you background and some of the arguments, and then we're going to talk about what happened at oral argument and how we interpret that. As I mentioned before, there's a statute called IEPA that allows the president, in the event of an emergency that has an international basis, to impose a variety of different measures on international transactions, including sale of goods, right? And I don't know, I think there are maybe a dozen verbs in the list of things the president can do. The president can simply block transactions entirely. Right, we're not going to import anything whatsoever from Iran, for example. The president can regulate transactions, but the one verb that is not on that list is tariff. Or
Tax.
yeah,
Yeah.
right. Yeah, I guess tariff could be a verb. Why not? Anyway, and so President Trump imposed global tariffs on basically every other country in the world. In fact, the initial list included some places that aren't actually even countries, but they cleaned that up pretty quickly. Based on an alleged balance of payments emergency. Now, we've been running negative balance of payments in trade for, since I was in high school, because I remember talking about it in a class. So it's at least not a fast-breaking emergency. But nonetheless, the president declared it to be an emergency, and on that basis, imposed broad tariffs, some individualization by country, and some of it just as a sort of baseline amount. There's another set of tariffs that are also involved in the case, but less prominent, where the tariffs were based on a government's failure to take what the president considered to be sufficient action about fentanyl that's reaching the United States. That's kind of a little bit of a side issue compared to the global tariffs. So there are a number of issues that were raised. One of them is that the absence of the word tariff or tax from that list is telling, and that the president's powers just don't include the ability to impose a tariff on imports. A related, maybe supportive argument is that the president's actions involved what's called a major question. There's an administrative law doctrine that's relatively new, but now well established, that if an agency or the president takes an agency takes what's classified as a major action, it needs really clear authority from Congress. Definitely not true here. There's also a claim that if Congress did give the president the power to impose tariffs like this, that would be an unconstitutional delegation of authority from Congress. So what did we find out at the oral argument?
All right, so we have 2 minutes, so I'll give you like the top line. I mean, this is sort of the case everyone's been waiting for, right? Because this is this is our first like big merits case in the last year or so. And of course, every case is going to be different. But what we saw is, I think, a little bit of what former Solicitor General Elizabeth Prelogar was talking about when she came for her Herman Hill K lecture last week or the week before, I think it was, where she said we now have a Supreme Court that you could think of it as 3-3-3 in some ways, where it's not necessarily a 6-3 court. And what we saw, I think, is that Justices Gorsuch, Barrett, and Roberts all expressed a fair amount of skepticism about this tariff authority. Justice Gorsuch said, if we get this wrong and we rule in favor of the president's authority here, there's very little Congress can do to get this power back. It's kind of a one-way ratchet, because they'd have to pass a new statute clarifying their intentions, but it would have to be veto-proof, right? Because the president would veto that. So he and Justice Barrett seemed really concerned about that aspect of the case. Justice Gorsuch and Justice Roberts also expressed skepticism about this idea that the taxation power, the tariff power, would necessarily be encompassed by these other powers. Their idea was that this is quite different, and this is a core power of Congress. And so it would be weird to have it delegated kind of sub silentio. So it would be really interesting, I think, here to see the Major Questions Doctrine, which is a doctrine formally announced by the Roberts Court, doing some real work in a way that actually sort of cuts against this president's interests, whereas in its earlier instantiations, it was used against President Biden. So it would demonstrate that this is a doctrine that can be used regardless of political consequence to read statutes.
Yeah, and I think, just to wrap things up in a nutshell, I think to the extent that previous rulings like the Trump immunity case made people fear that this court would be a rubber stamp for the president, I think regardless of exactly how this case comes out, they've made it clear that that's not true, that there are limits and that they are not willing to embrace everything a president does because that's the president. And at least from my perspective, that's pretty encouraging for the future.
So we didn't get to cover nearly all of the things we wanted to talk about. I'm sorry we didn't leave time for you to ask questions, but I would just say to all of you, I think this is a really important time to be taking constitutional law, to be taking administrative law. It's a little bit of an ad because I'm teaching it in the spring, but we'll be teaching it next year too, other professors, if you don't want to take my class. I've heard sort of rumblings that things are changing so quickly, I'm going to wait for things to calm down and then take some of these big public law classes. I would advise against that. I think this is a time to stay on top of what's happening in our government, on top of what we as lawyers what our role is to play in all of those changes. So we hope to see you in our classes in the future.